Let's review the Statute of Frauds, which is another requirement for contract formation. The Statute of Frauds requires that some contracts be in writing and signed by the party to be charged in order to be enforceable, unless an exception applies. Let's talk first about how a party uses the Statute of Frauds in litigation. Then we will cover the rule's elements. One party, usually the defendant, the party charged with breach of contract, asserts the Statute of Frauds as a defense to enforcement of that contract in order to avoid contractual liability. This party is arguing the contract did not form because there isn't a signed writing. Courts commonly use a three-step analytic framework to resolve statute frauds issues. First, the court asks whether the contract is of a type that is subject to the statute of frauds. If so, then the court asks whether there is a writing that satisfies the statute of frauds requirements. Third, if there is not a writing that satisfies the statute of frauds requirements, the court then asks whether there is an exception to the statute of frauds that applies. The first step in the three-step analytic framework that courts use to analyze a statute of frauds issue is whether the contract is a type that is subject to the statute of frauds. Another way to ask this question is whether the contract is within the statute of frauds. Although the statute of frauds varies from state to state, a signed writing is generally required for 6 categories of contracts. Those in consideration of marriage, those where performance takes over 1 year to complete, those for the sale of an interest in land, those for an executor to personally pay the debts of an estate, those for a sale of goods of $500 or more, and suretyship agreements. A commonly used mnemonic for remembering these 6 kinds of contracts subject to the statute of frauds is my legs. Of the 6 categories, the trickiest is the 1-year provision. Contracts that expressly, by their terms, cannot be performed within a year of the date they are made are subject to the statute of frauds and must be in writing to be enforceable unless an exception applies. If there is any possibility, even if remote, that performance could be completed within a year of the date the contract is made, then the contract is outside the statute of frauds. Is a contract for lifetime employment within the statute of frauds? No, because it is possible that performance would be complete within a year if the employee dies. The second step in the 3-step analytic framework that courts use to analyze a statute of frauds issue is whether there is a writing that satisfies the statute of frauds requirements. This is sometimes called a sufficient memorandum or a satisfactory writing. We'll use both terms. The following are the requirements for a sufficient memorandum for the purposes of the statute of frauds. First, any writing. The writing does not have to be a formal written contract. An agreement on the back of a napkin has been held sufficient. Moreover, the writing can be electronic, via email, or the like. Note that writings can be combined to satisfy the statute of frauds writing requirement, as long as the writings relate to one another. Second, identity of the parties. The writing must identify the parties to the agreement. Third, subject matter. The subject matter of the contract must be stated in the writing or reasonably ascertained by reference to other evidence. 4, essential terms. The writing must state the essential terms of the contract with reasonable certainty. 5th, signature. The writing must be signed by the party to be charged, meaning the party seeking to avoid enforcement of the contract on statute of frauds ground. Initials on the document will suffice. Buyer and seller enter into an oral agreement for the sale of a one-room cabin in the mountains near a ski resort for $70,000. Buyer sends a signed email to seller that accurately sets down the terms of the oral agreement. Seller refuses to sell the property. Has the writing requirement of the statute of frauds been satisfied as to seller's obligation? No. Although the writing contains all of the terms, seller has not signed it. The party to be charged is the person who does not want to perform the contract. Here, the defendant if a lawsuit were filed. Only person who signed a writing was buyer. Since there is no signed writing from the seller, the party to be charged, the statute of frauds is not satisfied. The UCC requirements for a sufficient memorandum are more liberal than the common law. There are two tests for determining whether writing is sufficient for UCC purposes. The first test is in UCC section 2201 subsection 1, which states the general requirements for a sufficient memorandum. 1. Any writing that evidences the contract. The writing must sufficiently indicate that a contract exists. The writing must state a quantity, and the writing must be signed by the party to be charged. The second test is the merchant confirmation rule in UCC section 2201 subsection 2. Unlike common law, UCC section 2201 subsection 2 provides that an oral agreement by the party against whom enforcement is sought is sufficient to satisfy the statute of frauds if certain requirements are met. 1. Both parties must be merchants, as that term is defined in UCC section 2104. Second, within a reasonable time, the party against whom enforcement is sought must have received from the other party a confirmatory memo, meaning a writing confirming the contract. 3. The confirmatory memo must be sufficient under UCC section 2201 subsection 1, as we discussed in the previous slide. And 4, the party against whom enforcement is sought does not object to the confirmatory memo in writing within 10 days after receiving it. This is a challenging rule to apply. Let's walk through a basic example. Seller manufacturer orally agreed to sell jeans to buyer retailer. Seller asked buyer to send purchase orders. Buyer did so. That same day, buyer received written confirmation that seller received the purchase orders. Seller did not object to the purchase orders. Seller failed to deliver the jeans. Buyer sues to enforce the agreement, but seller asserts the statute of frauds as a defense. The issue is whether the purchase orders qualify as confirmatory memos within the merchant confirmation rule, such that seller cannot assert statute of frauds as a defense. Here, the merchant confirmation rule would bar the seller from asserting statute of frauds as a defense. This is a transaction between merchants. Seller received the purchase orders, which are written confirmations of the oral agreement. The purchase orders are sufficient confirmatory memos against the sender, here the buyer, because they state a quantity term and are signed by the buyer. Seller failed to object to the purchase order's contents within 10 days of receiving them. As a result, the contract can be enforced against the seller, even though the seller has not signed. The third step in the three-step analytic framework that courts use to analyze a statute of frauds issue examines the exceptions to the writing requirement. Even if the scenario falls within one of the categories of contracts normally requiring a writing, the lack of writing will be excused where one of these exceptions applies. Generally, there are 5 common law exceptions to the statute of frauds writing requirement. The first is promissory estoppel, discussed in another video in this series. The second is full performance by all parties. The third relates to contracts that fall into the over 1 year category, where one party fully performs a contract that cannot be performed within a year, then this exception applies. Fourth, part performance relating to land sale contracts. Courts may grant specific performance of an oral agreement for the transfer of land if the buyer takes possession of the property and makes valuable improvements. Fifth, an admission in court by the party to be charged, where the party to be charged admitted to the contract's existence in court, for instance, in testimony or pleadings, then this exception applies, and the writing requirement does not need to be satisfied. Under UCC Section 2201, subsection 3, there are 3 exceptions that satisfy the statute of frauds if there is no sufficient memorandum. The first is part performance, where the seller has received and accepted payment for the goods, or the buyer has received the goods and accepted them. Note that this exception only satisfies the statute of frauds with respect to the particular goods that have been accepted by the buyer, or for which the seller has accepted payment. The second UCC Article 2 exception to the statute of frauds is admission. Admission of the contract's existence by the party to be charged in court through pleadings, testimony, or otherwise is an exception to the statute of frauds writing requirements. Third, specially manufactured goods. Specially manufactured goods are those not suitable for sale to others in the ordinary course of the seller's business. For this exception to apply, the seller must have substantially begun manufacture of the goods or made commitment for procurement of the goods.